Starmer.
Thank you, Mr. Speaker, and can I thank the Secretary of State for early sight of his statement. This is a good day for parliamentary sovereignty. The Supreme Court has ruled that we shall have a say in this House on the Article 50 issue. Given the issues involved, that is quite right, and the Prime Minister was wrong to have attempted to sideline Parliament in this process. This bill is only to be introduced because the Prime Minister has been ordered to do so. Now, I hope in the aftermath there won't be the attacks on our judges that there were when the High Court gave its ruling. And it's the duty of all of us to defend them if they do, and to do so quickly. And I hope the Secretary of State will join me in that endeavour. The question now moves on to the proper role of Parliament. And the Supreme Court said nothing about the particular form of legislation. But on issues as important as this, it would be wrong for the Government to try to minimise the role of Parliament or to seek to avoid amendments. And I ask the Secretary of State to confirm that he won't take that approach. This is a question of substance, not process. Last week, the Prime Minister committed herself to swapping the known benefits of single market membership and the customs union for the hoped-for benefits of a free trade agreement, with a fallback position of breaking our economic model. That is high risk, and there are big gaps, inconsistencies and unanswered questions in the Prime Minister's approach. Mr. Speaker, if the Prime Minister fails in her endeavour, the cost will be borne by families, working people and communities throughout the UK. The stakes are high, and the role of this House in holding the Prime Minister and the Government to account throughout the process is crucial. Labour accepts and respects the referendum result and will not frustrate the process. But we will be seeking to lay amendments to ensure proper scrutiny and accountability throughout the process. That starts, Mr. Speaker, with a white paper or plan. A speech is not a white paper or plan, and we need something to hold the Government to account throughout the process. Can't have a speech as the only basis for accountability for 2 years or more. That's the first step. There needs to be a reporting back procedure, and there needs to be a meaningful vote at the end of the exercise. The Government should welcome such scrutiny, not try to resist it, because the end result would be better if scrutinised than it would otherwise be. I hope the Secretary of State will confirm that we will not seek to minimise scrutiny and accountability. I'll leave others to say about the devolved administrations, but I think whatever the Court ruled, it is important that those interests are taken properly into account. I end with this, Mr. Speaker. What a waste of time and money. The High Court decision was 82 days ago. The Prime Minister could have accepted then to introduce a bill. We could have debated the issues, and I'd like the Secretary of State to lay out what the cost to the taxpayer have been of this appeal. Thank you, Mr.